Good morning and welcome to today's webinar, Trustee Selection, How to Choose the Right One for You, presented by Elville and Associates, Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here, and if you're returning, welcome back. You as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation yesterday by email for me to take notes on it if you wish. If for some reason you did not receive the presentation, it's currently available for download in the section marked Handouts in the panel on your screen at this time. For CFPs, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. Per my attendance records requirements, please email me your ID number, and for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And as always, we ask that you please just take a couple minutes to fill out this simple survey to offer us your feedback about the presentation, which we value very much. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have now or in the future. And here at Elville & Associates, we always look forward to being a resource to you now and in the future. So briefly, I'd like to give you an overview about our firm and share a bit about Steve, and then we'll jump right into it. So Elville & Associates, as I think you can see my screen, we were founded in 2010 in Columbia. Right here, we're in the Columbia Gateway Drive location here at Elville & Associates by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm: estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and again, we're here in Columbia today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, which is one thing that makes us very different from a lot of other firms out there. And we do that in a number of ways: through our planning processes with our clients, through over 100 educational webinars and workshops in the communities we serve each year, and also by way of our Accredited Client Care Program, or CCP, as we like to call it here at the firm. We are one of only 2 firms in Maryland to have a CCP accredited by the Client Care Academy in Boston. It's a program that has many robust benefits that our clients like to take advantage of throughout the year, including a number of different legal education events solely for those members. So if you want more information, please let me know, and I'll be happy to share that with you and talk to you offline about it. A little bit about Steve. Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different membership organizations throughout the country, a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Also, last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, a very seasoned speaker if you haven't heard him speak, each year presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for a 6th time in 2021, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of as well. and we work with many schools and other organizations to give the gift of music to students that want to participate in music but may not have the means to do so on their own. So if you'd like to learn more about that and our endeavor, please reach out to me and I'll be more than happy to share our story and let you know how you can get involved. So that's a little bit about Elville and Associates and Steve. If I can back out of my little program there, we're going to start off with a brief poll, just take about 90 seconds, just to get to know our audience and who we have joining us today. And the poll is, what has brought you to today's webinar? So please select the response that applies to your current situation. And you should see a box pop up on your screen. And the choices are, I'm a grantor, I've established a trust before, I've been or am a trustee of a trust, I am the beneficiary of a trust, I'm considering establishing a trust, or lastly, I'm an advisor here to learn to better serve my clients. So take just a few seconds to select the choice that best suits your situation. We'll get an idea of who's with us today. We all hope you're having a great day out there and enjoying the weather. Holidays are right around the corner. They're earlier and earlier every year. Steve and I have been talking about. We'll give it another few seconds here. Okay, we've got about 80% having made their selection. So we have 21% saying, 20% saying I'm a grantor, I've established a trust before, 13% saying I've been or am a trustee of a trust, nobody says I'm the beneficiary of a trust, 47% say I'm considering establishing a trust, and 20% say I'm an advisor here to learn to better serve my clients, which is always a great thing. So welcome everybody. I'm going to go ahead and turn the reins over to Steve here. I'm going to make you the presenter, Steve.
Thank you, Jeff.
See that button pop up. I'm going to close that poll out too. See that button, Steve?
All right, let me see if I can get, I don't see it yet, Jeff.
Okay, let me try that one more time.
There we go. Thank you, sir. All right, I'm almost where I need to be. And I'm going to start my slideshow. All right, well, I thank you, Jeff, and thank you, everyone. Good morning. I'm Steve Elville, and I'm coming to you from our conference room number 1 in Columbia, Maryland. It's a beautiful day outside. As Jeff said, the holidays are coming up. They're cutting the grass outside of our window here, so hopefully you won't hear any noise, but it's beautiful, and Halloween is almost here, so hopefully you're going to be having fun with children and grandchildren and so forth. I want to thank Jeff. He is our moderator. He is an expert at this, and without him, we could not do this. He is my longtime colleague, and if you have questions about the material we're going to talk about, please let Jeff know. He will interrupt me. I will also stop at various times in the presentation to see if you have questions. And again, I want to say it's my great privilege to be with you this morning, and we love to educate here at Elville and Associates, along with our advisor and referral partners. And I just want to say that this particular topic, the trustee selection topic, is one of our most popular webinars. And what could be more important, whether you're establishing a trust or you have a current trust and it's for your children or grandchildren or nieces or nephews, trusts for spouses, trusts for special needs beneficiaries, trusts for life insurance in this day and time where we have laws that are changing and we may need life insurance trusts more than ever. What could be more important other than trustee selection? And as we go through this presentation this morning, which I hope you will embrace as a tool for you and use it as a practical guide, I want you to know that some of this is written from the perspective of course, the topic, which is how to choose a trustee. Some of it actually kind of morphs into the actual trustee duties. The reason I've done that is to give you a bird's eye view of what it means to be a trustee so that you can understand the trustee's responsibilities as you think through the process of who's the right person to choose for these responsibilities. So to me, it is one and the same. You know, the trustee selection ideas and considerations, and also the actual trustee duties, because that's, to me, important about who you would choose. So again, what could be more important? And this is a compilation of my experience over the last many years and dealing with hundreds and thousands of trusts and wills in estates. So let's just get started. And again, thank you for being here. So what are we going to discuss today? Well, what is a trustee and what are their responsibilities? So some of this is going to be very basic. I'm not going to make any assumptions about what you know and what you don't know, so I'm just going to start from the basics. We're going to talk about the types of trustees and what are their advantages and disadvantages. What are their characteristics? We're going to talk about the perfect trustee. If that person or organization is out there, we want to find them, and we're going to set some benchmarks for selecting them. Trustee selection, why is it important? Well, we just talked about that a little bit, but we're going to talk about it more. Trustee succession, why is this a crucial consideration? Not just who our initial trustees are going to be, but who are the successor trustees? What are the various roles of trustees? Not just the kinds of trustees, but what are their roles in wills and trusts? And you're going to see that there's overlap here, and hopefully that will make sense. What are some of the reasons to consider appointing a corporate trustee? And so a corporate, or not just an independent person, but let's say an actual corporate trustee, like a trust company or a bank. And back to the issue of successor trustees, what is the risk involved as you consider succession and the plan design? What are the risks? Okay. And we will also talk about corporate trustees in more detail. So what is a trustee and what are their responsibilities? So as we get right into this subject matter, we're going to administer the trust if we're a trustee. Now remember, a trust can be established under a revocable living trust, or it can be established under a will. So don't be thinking that it's just trusts that can be established that this is applicable to. A trustee needs to follow the terms and provisions of the trust. So in other words, we have trustees out there that unfortunately don't read the terms and provisions of the trust. And unfortunately, that is not a good idea. So we want to make sure, as fundamental as it sounds, that our trustee is reading the terms and understands the terms and provisions of the trust and that they're following them. We want to keep accurate records. We want to make sure that the trustee knows how to account to the beneficiaries. So a good trustee in this day and time will always account. Now, I see a trend in trust administration where accountings are few and far between. Professional fiduciary accountings are not produced as often, in my opinion, because of the rise of technology and the fact that statements from financial institutions are more sophisticated than ever. But I think the fundamental still exists that a trustee has the obligation to keep accurate records and to account to the beneficiaries. Making distributions, whether they're mandatory or discretionary according to the terms of the trust. So we're right back now to making sure that we understand the terms and provisions of trust. To make trust investments, so the trustee has to have the knowledge of at least understanding the basics of investments. I'm going to make the argument that the trustee, unless they are a professional, should not actually be making the investment decisions, and they should hire professionals to do that. But the trustee must, either themselves or through an agent, which would mean that the company or the brokerage firm must be making prudent trust investments. The trustee has to communicate with beneficiaries, ensure that tax filings are complete, and manage taxation of trusts. So trusts are taxed in a different way than individuals. And the trustee needs to understand that and make sure that they have hired professionals most of the time. The trustee can do the trust tax return, which is a 1041, of which we're going to talk about in more detail. But the trustee, in my opinion, should not do that and should delegate that to a professional. So let's get into some definitions. What is a trust? Well, a trust is a relationship. A trust is a relationship that springs from an agreement. And this agreement is between a grantor, and you notice that Jeff used that term in his poll. A grantor in these days is the modern term for a person who establishes a trust. In the old days, that might have been known as a trustor or a donor, okay? So now we call it a grantor. And of course, the trustee is also part of that agreement, in essence, to provide for the benefit of the beneficiary. So the parameters and roles and responsibilities are described in the trust and is governed under applicable trust law. So this is why we have to have a trustee that understands their responsibilities and a trustee that understands the terms of the trust. And again, who are the parties? It is the grantor. Another old term that was used was called the settlor, the person establishing the trust. And again, the trustee is the person who is actually accepting the property. So if you are ever asked to be a successor trustee and you take on the role of the trustee, a proper thing to do is to sign a trustee acceptance form, and your trustee would be accepting the trust property, and you agree to manage and distribute that for the benefit of the beneficiary. And of course, the beneficiary is the person for whom the trust property is intended to benefit, and the trust provides how and when and so forth that person receives benefits. And remember, one basic concept that I want you to keep in mind is that a trust is for the benefit of a beneficiary. Either distributions are made either to that beneficiary or for the benefit of the beneficiary. So a trustee's responsibility is to distribute or manage the trust property for distributions to the beneficiary or for the benefit of the beneficiary. Now, trust basics for purposes of this webinar are really to think in terms of the types of trusts that are out there, basic trusts. We have revocable trusts, which many of you may know about or already have. And revocable trusts are what? They are just substitutes for a will. So in very basic estate planning, we are looking at establishing either a will-based plan or a revocable trust-based plan. And a revocable trust is a grantor trust, and we're going to get into more detail about that. But a grantor trust is just simply a trust that the grantor pays the taxes for all the trust income. So the revocable trust is a very basic will substitute, and it can be modified or amended at any time. And it is a very basic form of a substitute for a will. Now, an irrevocable trust, generally speaking, although there are exceptions nowadays, may not be amended or modified. And this could be a standalone trust where you've established an irrevocable trust like a charitable trust or a gifting trust or a life insurance trust or a special needs trust that's irrevocable, or a lifetime marital trust. These are more complicated or more advanced estate planning tools. But those are examples of irrevocable trusts. And irrevocable trusts can either be grantor trusts or non-grantor trusts. We're going to talk about that. But these are usually taxed as standalone entities. These are usually something that's going to have a tax ID number, and there are various points of view on that. So just understand that revocable trusts and irrevocable trusts are different. And of course, an irrevocable trust could be a trust that's established at death. So when we're talking about our trustees, we have to make sure our trustees are educated about the different kinds of trusts and when these trusts are actually effective, whether it's during life or at death, and whether the trust is revocable or irrevocable. Now, we just talked about some of this, but traditional revocable trusts, these are basically avoidance of probate tools. They're just probate avoidance tools. It's a substitute for a will, okay? And these provide for privacy. They avoid probate if they are properly done. So let's talk about the role of a trustee in a proper revocable trust. A trustee, whether it's yourself or whether it's a successor trustee, is to make sure that revocable trust is funded with your assets. So remember, a revocable trust has two phases. The first phase is the implementation phase, and we're talking about the trustee needing to know this now. The second phase is the funding or alignment phase, where we're aligning assets in the trust. we're either retitling assets in the trust, or we're making sure that assets that are outside the trust are aligned properly, that they're going to flow at death in the proper way. So a trustee might enter into a role as a successor trustee and find that the revocable trust is not properly funded. And assuming that they have the power to do this, they would make sure the trust gets funded. So trusts for at-risk beneficiaries, for example, a trust for a child. Now we're getting away from revocable trust. Let's say this is a trust during life that's established as an irrevocable trust, or a trust established at death for the benefit of a child who is either a minor or disabled, or that person is not able to manage their own affairs, or they have health issues of some kind, or they are spendthrift children. So all of these kinds of beneficiaries can be provided for by irrevocable trusts, and the trustee needs to understand your intention and needs to follow that intention, not just the terms, the bare terms and provisions of the trust. So along these lines, we could just take a side here for 30 seconds on memorandums of intent. So if you are establishing a trust and you want that trust to be supplemented with a letter of wishes or a memorandum of intent that will provide further instructions to the trustee, very personal instructions from you for the trustee, I would strongly encourage you to use a letter of wishes or memorandum of intent. And Jeff can certainly make sure that you get a copy of a letter of wishes if you're interested in knowing that. But my point of kind of digressing into that subject for just a second is just to talk about the trustee's responsibility of basically carrying forth your intentions. And the trustee can much better do that if they have an idea of what your true non-formal, informal intentions are, not just the terms and provisions of the trust, but a memorandum of intent or letter of wishes. And of course, the last bullet point here is the trust can last forever. So for example, in Maryland, we have no rule against perpetuities. So here is a trust that can be put in place forever until the money is completely gone. And that's why that we need to think carefully, not only about initial trustees, but how will trustee succession occur down the road. And of course, we have beneficiary controlled trusts. These are trusts where you can establish a trust for a beneficiary, but give them some level of control. And this is a good and bad thing. Maryland, for example, is a jurisdiction that says a child or grandchild or niece or nephew can actually be in control of their own trust, and they can have asset protection, or what we would call spendthrift protection from creditors. However, there are exception creditors. These are Uncle Sam in case of taxes, alimony and child support. Those are exceptions or exception creditors that could actually get into a spendthrift trust no matter what. So we can't protect against those kinds of public policy things. But what we need to be aware of is that the beneficiary can have some reasonable level of control, but we have to juxtapose that with the fact that what if they have too much control? Certain jurisdictions in the United States do not agree that a trustee can be in control of their own trust, and therefore that trust could be subject to the claims of creditors if there's not an independent trustee. So the trustee that you establish in your planning has to understand these concepts along with the trust protector. So the trust protector is someone who is a special fiduciary, and I can't recall whether we're going to get into trust protectors in this presentation, but I just want to say that the selection of your trustee and trust protector is critical to the carrying out of your intentions, in my opinion, along with a letter of wishes. And of course, there are special needs trusts that can be established. If you have a special needs trust, whether it's the third party type, the third party type is when you or someone other than the beneficiary are leaving money into a third party supplemental needs trust for the benefit of the beneficiary, or whether it is a self-settled first party trust where the beneficiary has already received money that they should not have in their own name, and that has to be taken out of their name and put into a first party trust of some kind. There are 2 or 3 different versions of that trust. Regardless of what kind of special needs trust it is, we need a trustee in those circumstances that understands special needs, understands how not to destroy the benefits of a special needs loved one, and to make sure that that trust is administered properly, so that in most cases, what is being done is carried out, which is having that money as a supplement for the special needs beneficiary while not disturbing their means-tested public benefits and not destroying those means-tested benefits for the long term in the future. All right, so I'm going to stop for just a minute. We've been going for about 15 minutes or so, and I just want to stop and see if there are any preliminary questions that anyone has as I'm kind of moving through the material fairly quickly.
Thanks, Steve. We do have one question, and that question is, what is a tort creditor?
Thank you for that question. So a tort creditor, at simple definition, a practical definition would be someone is driving down the road, they have a car accident, and you're at fault, the person is at fault, and they cause injury to another person, and now there is a lawsuit against the driver that was driving that caused that injury. That basically would be a tort action. That is an action that's adversarial in litigation. And that's a non-technical answer, but that's more of a practical definition.
Okay, thank you. That's everything for now.
Very good. Thank you for that question. Okay, so common trusts, again, that are being implemented have to have a trustee and a beneficiary. And again, just being intentionally redundant, the trustee is the person who accepts the property that is placed into trust and who agrees to manage that property for the benefit of the beneficiary. So a trustee is a fiduciary. They have a fiduciary responsibility to not self-deal and to make sure that they are using the property properly for the person who is the beneficiary, and that they are accounting to the beneficiary as needed, and any other interested person, especially in a special needs situation, they're accounting to someone who might have the authority to demand an accounting. And of course, the beneficiary is the person or persons for whom the trust is established, and the trust is provided in distributions to this person or persons, either to them or for their benefit. All right, let's spend just a few minutes talking about grantor and non-grantor trusts, and also these terms of art in our industry called qualified beneficiaries. But I'm going to go back quickly to this slide, and I'm just going to describe this again so that you can have a frame of reference. So grantor trusts are trusts, very simply, where all trust income is attributed to the grantor. Now let's spend just a minute on this. Those of you who are reading the newspapers and the internet understand that right now Congress is in the middle of a major tax battle over the reconciliation bill, and basically trying to come to grips with the tax proposals that were started as early as last March by Senator Sanders with his 99.5% Act, and Senator Van Hollen with the STEP Act, President Biden's American Families Plan, and now the September 13th, 2021 proposals by the House Ways and Means Committee, and everything that's being put forth in front of Congress right now. One of the issues is whether or not grantor trusts will continue to have favorable treatment. Now, this is not necessarily pertinent to our discussion today about successor trustees or trustee selection, but I think that this is just another example of just how much a good trustee should really understand. They should really understand the difference between the grantor trust advantages, which is that someone can create a trust like a simple revocable trust, or they could create a life insurance trust, or they could create a gifting trust of some kind, and they can be attributed the income from that trust and have to include that income on their own tax return, and therefore the trust does not pay the tax and the beneficiaries are not responsible for the tax, versus a non-grantor trust. So a non-grantor trust would be, a good example would be, I pass away and I leave my child or children further trust to protect them for whatever reason, whether they're special needs beneficiaries, whether they are need protection from a bad marriage, or whether they need protection from themselves or from creditors generally. That trust at death is definitely a non-grantor trust. That is a trust that will have its own tax ID number, and that trust will be responsible for its own taxes. And that's a little bit of a separate issue about how trusts are taxed. And initially, the trust tax rates are very high compared to individuals, but those taxes and the attribution of tax can be managed through the passing out of income to beneficiaries, and they pay the tax on their own tax return. But basically, for your purposes today, we need to understand the concept that a grantor trust is a trust that is in flux right now in Congress about whether Congress will continue to allow the benefits of a grantor trust, not for revocable trust, but for more advanced grantor trusts like life insurance trusts and other trusts, or whether they're going to just allow us to continue to use this as a tool, which we have for many, many years. A grantor trust is a trust where the trust income and the income tax is attributed to the grantor. And a non-grantor trust is a trust that is going to pay its own income tax if it's not passed out. If that income is not passed out to beneficiaries, that trust will pay its own income tax, and it has a tax ID number, generally speaking. Now, in 2014, a trustee needs to know about this. The Maryland Trust Act was implemented, and this was a huge thing. It got national recognition. Maryland really needed to update its trust laws and its trust code in the Maryland Code. And so the Maryland Trust Act was established. And one of the reasons it was established is because beneficiaries of a trust really were never, they were not entitled to notice, they were not entitled to information. So now the Maryland Trust Act says that there are qualified beneficiaries, that a beneficiary, if they meet the definition of a qualified beneficiary, which they can easily do, is entitled to notice. They are entitled to information. And in my view, they're entitled to almost all information, although that may not be convenient for the trustee. So a trustee has to understand this. They have to understand that there are certain legal requirements of notice, and you'll see those published here. And you'll notice at the bottom of these bullet points, Maryland is not a state that has a quiet trust. That means, for example, in Delaware, you could establish a trust and the beneficiaries don't get this kind of notice, or that you can avoid it in certain ways. So for better or for worse, Maryland does not have a quiet trust. And I would say generally this is a good thing. Beneficiaries are entitled to notice, just like in an estate, meaning a probate estate where beneficiaries are entitled to notice. Well, here we have a situation where if a trustee takes over a trust, that trustee has certain requirements to notify people of their appointment, the qualified beneficiaries, and also to understand that the beneficiaries are generally entitled to, in my opinion, a lot of information, and to provide that information. And that gets to my next slide here, that the rights of a qualified beneficiary are they are entitled to a copy of the trust. They're entitled to annual reports. They're entitled to a report about the termination of a trust or the acceptance of a trust. So they are entitled to information, and I would argue entitled to information about all the trust property, all the potential distributions of property. Of course, there are limits to this that can be argued, but generally speaking, this is a big change in Maryland law that your trustee, as you think about selecting trustees, needs to understand this. Now, let's talk about the role of financial advisors. And again, this is not directly related to the selection of trustees, but this is also about the idea that I was describing in the beginning, which is, what does your trustee really need to know? Well, I think they need to know about financial advisors, especially the non-professional trustee, and what is their role and how to work with them. So the financial advisor, in essence, opens trust accounts, and the trustee is going to be responsible for getting that started. They are going to be concerned about a lot of things. And for the financial advisors on the call here today, thank you for being here. This is not an all-inclusive list, so just know that. But they're going to want to know things like, are there more than one trustee? Do duplicate statements need to be sent out? Is the trustee going to be looking for a money market account that's associated with the brokerage type account that's normally associated with a trust account? Is income to be reinvested or paid out to a certain beneficiary, and so forth? And then, of course, a trust could be funded with in-kind assets. So the financial advisor is going to help with the transfer of assets. Let's pretend there's a certain stock that was owned at the time of the decedent's death. And let's say the decedent didn't want that stock sold. The decedent just wants that stock to be continued to be held in kind for the beneficiaries. So all of these things, stepping up the basis after someone's death, these are all things that the financial advisor does in coordination with the CPA, who hopefully is involved, and the trustee. So just real quickly, and I want to make sure that I'm covering that and don't miss it, remember that along these lines of my talking about a financial advisor's involvement here, we really should, if we're thinking about a trustee, we want a trustee who understands the terms of the trust, is going to communicate and do all the things that I'm going to show you here in just a few minutes about the perfect trustee and what they would do. But we also want them to be collaborative. We want the trustee to collaborate with a financial advisor, a CPA, and have an advisory team. This is in the best interest of the trustee, and this is in the best interest of the beneficiaries. Why is it in the best interest of the trustee? Well, the trustee should know that they have a fiduciary responsibility, and they need to be making decisions with that in mind, whether it's the investments of the assets, the distributions of the assets, and they want to understand the beneficiary and what the beneficiary's needs are, and not be too conservative and not be too liberal, perhaps. Every situation is different. The trust terms are going to be different. The letters of intent are going to be different about what the grantor of the trust wants. But long story short here is that we want the trustee to be working collaboratively and getting high-level advice from the financial advisory team and the tax team, not just working in a vacuum. Now, of course, the financial advisor is going to be managing the trust portfolio. And here are the questions the trustee needs to be asking themselves. And we've seen examples of this that are very, very poor. So we want to avoid that outcome. Is the trust geared to income or principal growth or unit trust distributions? So for example, if a trust is really designed to put off a lot of income, but the trust is invested in a way that's contrary to that, then the trustee is not carrying forth the intentions of the trust. That's a simple example. Now, of course, we just talked about the fiduciary responsibility of a trustee and the ongoing cash needs of the trust. Is there a beneficiary with monthly expenses? The trustee has the responsibility of understanding this and creating a plan for the beneficiary. Now, I'll stop here in just a second for more questions, but I'm going to go through this concentric circle slide. And those of you who have seen presentations from us before know that I always like to say to Jeff, Jeff, one day we're going to put a picture in here or some photos of some trustees that are just perfect individuals. These people are wonderful advocates. They understand if it's a special needs beneficiary, they understand their duties and responsibilities as advocates. They understand public benefits. They're promoting the well-being of the beneficiaries, whether or not they are special needs beneficiaries or not. But they're also savvy and they understand financial investments. They understand that what they don't know, and they hire professionals. They understand taxes and what they do and don't know about taxes, and they hire professionals. But they are very, very zealous account keepers. They understand records and they keep beneficiaries informed, and they understand their duties. I was speaking with someone last night who is the beneficiary of a trust, and this person was, to their credit, seeking professional advice about how can I best manage the assets of this trust? What are my duties? What am I to do about distributions and investments? So this was a great example of a trustee who was seeking out professional help and understands. But my point is, this is the benchmark. These concentric circles, in a nutshell, represent a benchmark that I want you to be thinking about as you think through the idea of who will be my trustee, who will be my successor trustee. Jeff, I think I've gone another 15 minutes, maybe more. I'm going to stop just to see if there are any further questions at this point.
Thanks, Steve. We do have one that just came in, so let me go ahead and read through that. If the trustee of a special needs trust works with a team of advisors, a tax accountant, financial advisor, etc., can the trustee use money from the trust to pay for these professional services?
Thank you for that wonderful question. The answer is yes. Generally speaking, I think that would be yes under state law as well. But trusts are considered to be governed by the circuit court. Now, that doesn't mean that trusts always go to the circuit court. Hopefully, your trust will never do that. But the reason I bring that up is the terms of the trust control. And unless the trust specifically says you can't do that, then it's just a given in trust administration that you can use the trust funds to hire professionals. It's always good if your trust is comprehensive enough to say that and make it very clear. But I think it's a given that you as a trustee or the trustees of that particular trust can hire professionals and use the trust funds to do that. And that is considered to be a prudent thing to do. So for example, along those lines, when and if you hire a financial advisory firm, if you were the trustee, then what you're going to want to do as a trustee is say, listen, I'm a fiduciary myself. I'm looking for you, the financial advisory firm, to be a fiduciary in your advice to me and in your management of the trust assets. And along those lines, I want you to provide me with something called an investment policy statement. An investment policy statement that gives me something in writing that says, I have exercised my fiduciary responsibility by being diligent, and I will be diligent with you in the future for follow-up meetings, but you're assuring me that the trust assets are being invested properly and that I'm exercising my responsibility as a fiduciary, and so are you. So that's a wonderful question. The answer is generally yes.
Okay, thank you. We do have one more. How closely are the District of Columbia requirements aligned with Maryland?
That's a great question. I am not barred in DC myself. We have attorneys here at Elville and Associates that are. I wouldn't be able to speak to that issue directly without consulting with them or having them answer your question. So please feel free to email Jeff and we will get back to you about that. There are differences in the district and in Maryland. There's differences in the approach to estate tax and inheritance tax and other things. So certainly there are differences and I wouldn't be able to articulate them here, but we certainly want to answer that question.
Okay, one more question. Have somebody asking if you could please show the last slide with the concentric circles.
Oh, certainly.
Apparently it didn't print out very well and didn't print out well in some printers for people. And I think we're looking for somebody to maybe jot some notes down from that.
Yes, we'll just leave that up here for a second and we'll just take a little bit of a break here. Just take your time there. And Jeff, we'll have to rework this slide so that it prints better.
Yeah, I think so. And, you know, the person asked if I could send the information out in color, and I typically don't because a lot of people don't have color printers, and sometimes it doesn't print out as well if I send it in color and then it has to get transferred over. But maybe I'll send it out in both color and in black and white going forward. So that's a good thought. So thank you for sharing that information. We'll address that for next time.
Okay,
see if there's any other questions while we're waiting here for just a moment. We do have another question. And the question, Steve, is if the beneficiary is also the sole trustee, should an independent trustee be actually named at the beginning, or is it sufficient to give the sole trustee beneficiary the right to name an independent trustee? For example, if he wants to distribute principal beyond health, education, maintenance, and support.
Yes, so I think that's a wonderful question, and my answer is going to be two-part. The first part is that we definitely want to have a mechanism where an independent trustee can be appointed. We definitely want some ability to either have an independent trustee from the beginning, as we say, from the get-go, so to speak, or you need to have a flexibility provision that says that an independent trustee could be appointed at any time. And you're welcome in planning to be able to say, well, if this particular trustee or if this particular organization who is an independent trustee, if they are still in existence at that time in the future when they are needed, they shall be appointed in the sole discretion of the trust protector. So first part of the question is we want to have the flexibility to name an independent trustee for sure, and you may or may not wish to name who that would be. The second part of the question is we don't want the beneficiary to be directly involved in any switching of trustees. The beneficiary needs to be arm's length from this, and the person who is creating the successor trustee or the new trustee or appointing the new trustee, that person also needs to be arm's length. And that's why we want to talk in terms of a trust protector. Maryland calls it a trust advisor. Most other states call it a trust protector. And this is a special fiduciary who has the flexibility of naming an independent person or an independent corporate trustee to take over from a child who, of course, is the beneficiary of their own trust, and they are an interested person in their own trust. So they're not arm's length from their own trust. First part of your question, we definitely want to provide for that. Second part of your question is we want a trust protector to be able to have that discretionary authority.
Okay, thank you. And those are all the questions for now. Thank you for the
Perfect.
questions, everybody.
Well, I think we're way ahead of schedule. We're going to have plenty of time for questions at the end, so I'm just going to keep moving on. Why is trustee selection so important? Well, for all the obvious reasons that we've discussed so far, but let me give you some other ones that you may not have thought about so far. Trust can last forever now in Maryland. Now, Maryland has a very powerful situation where there's no rule against how long trusts can last. Trusts are more portable than ever. So state laws in various states allow for trusts to be transferred from a certain jurisdiction like Maryland or DC to another jurisdiction simply because the trust terms say so. And of course, state law in many states are very much in competition. So we get to the third bullet point here. We have states that are in competition for trusts. For example, Delaware, Nevada, South Dakota, Alaska. These are states that want trusts. They want to administer trusts. They have large trust industries in those states. Those are particular states that are asset protection states, along with about 12 or 13 other asset protection states. Beneficiaries are likely to change their domicile. So our children today may be living in Maryland or maybe not, or DC, and then when they move, they may end up in a different domicile. So trustee selection is very important about trying to take into consideration, even though we cannot predict where children or other beneficiaries are going to live, we can put flexibility in our documents such as trust protectors and other flexibility measures to deal with this. Trustees have options. Trustees can resign. They can refuse to serve. We see this more often than I would care to admit, and I would caution you that if you are appointing an independent trustee or a corporate fiduciary, that you have to realize that those trustees, especially the corporate fiduciaries, they are not locked in, even though they will promise you that they will serve. Those trustees do have the option and sometimes do refuse to serve at the time they are very much needed. So that's another reason that trustee selection is important, but the flexibility to continue to deal with trustees, even if you run into those kind of circumstances, is even more important. Decanting, trusts can be changed, not only amended, trusts can actually be changed to an entirely different trust today under the terms of certain decanting laws, the ability to change a trust from one form to another, not just the amendment of a trust. That's another reason that trustee selection is important. Decanting can be used in good ways. Decanting can also be used in bad ways, and we want to make sure that our trustees take their fiduciary duties very importantly and take them seriously, and that they will not ever act against your best interest. And I've already covered the last bullet point about flexibility for changing circumstances. So the trustee selection process, this may be very easy for you. You may just be able to sit where you are right now and say, well, in my mental checklist, I know exactly who my trustees are going to be. My children, my siblings, other relatives, or this independent trustee that I've thought about. And that gets us to the next bullet point. But as you think through that process, I want you to think in terms of the nature of the question that was raised about a child being the trustee of their own trust, or a child being, I'm just going to take off on that point a little bit more, a child being the trustee of a trust for their other sibling, this kind of thing, where there's an interested trustee involved, whether it's for themselves or for someone else, versus having independent trustees, not only for practical personal reasons, but for asset protection reasons. I would argue the more independent the trustee is, the greater asset protection the trust has, generally speaking, depending on the terms of the trust. And this trustee selection process is usually done best in a process. And that's why at our firm, for example, at Elville and Associates, we try to engage in a partnership type relationship with clients. And Jeff and I have often talked about this, especially since all of the drama and all of the confusion of COVID over the last couple of years. And that is that clients need a place to think. Clients need a place to discuss the nature of wills and trusts, to visualize the future, to be able to discuss all the contemporary choices that are available to them in estate planning today. And here at Elville and Associates, we do that by giving you time to think. So this is done in the document review process. And that's where, again, what we're talking about, not rushing through the design process, not rushing through the review process, doing lots of homework, doing lots of considerations, lots of counseling in a partnership arrangement, and that's where this can best be done. We have to consider conflicts, and I just mentioned this a little bit, conflicts between interested trustees. Having a person who is an interested trustee, they are related to the other person, they are not independent, they are subordinate to the other person in the world of the IRS, in the world of trusts. So this is a conflict that's just waiting to happen. So we have to think about that. Individual versus corporate independent trustees. You could have a friend, you could have a trusted colleague, you could have a CPA, someone who's arm's length from you, and that person might make a good independent trustee versus a corporate trustee. And some of you may want the advantages of a corporate trustee. We have to consider those advantages and disadvantages. For example, a corporate trustee is going to have their fee schedule published by the Secretary of State, so it's fairly predictable. The corporate trustee is going to be a trustee that has to account every year. They do the trust tax return, generally speaking, versus an independent individual person, and that's where we have to get into that concentric circle trustee selection process and really be sure that we're checking off the boxes. So there are advantages and disadvantages depending on every situation. Again, the trust protector is a special fiduciary. Their general powers are the power of amendment, to amend a trust administratively if there are changes in the laws, if there are if there are ambiguities in the trust, to be able to make these changes or to make additions, depending on what the trust protector's powers are. But the trust protector can also remove and replace trustees, and this is one of the big advantages of having a trust protector. Even though it does involve more work, it involves more considerations, it is a difficult thinking process for some people, and it takes an open mind to understand that the trust protector is recognized by the world of the IRS, recognized by Maryland, recognized in the United States as an entity that's arm's length, that can make certain changes to a trust and amend a trust and make sure that the grantor's intentions are carried out. We just talked a little bit about interested trustees versus independent trustees. So there are different standards of distribution. One of the listeners here that posed a question talked about the difference between being able to distribute for any purpose, meaning a discretionary standard, versus being limited to health, education, maintenance, and support. So this is a counseling issue. There are different points of view, different levels of objectivity and oversight. For example, if you're considering a corporate trustee, I would strongly encourage you to talk to the people who would actually be managing the trust on the ground, wherever your beneficiaries are, and not just to a representative talking on a very high level about what the independent corporate trustee does. We want to know, what will they actually do on the ground under practical considerations? And that's what I would encourage you to think about. I got ahead of myself a little bit, so let me circle back to the trust protector. I tend to do that from time to time. They are a special fiduciary in Maryland. They must act as a fiduciary in a fiduciary capacity. I've told you some of the background, but just know that trust protectors, in my view, came from the asset protection states like Nevada, Delaware, Alaska, Wyoming, and so forth, South Dakota. And there are many other asset protection states. These special fiduciaries can now be used in Maryland. And again, we've had this since 2014. Firms like Elville and Associates were using trust protectors in documents far before 2014, but now it's recognized officially in Maryland. The trust protector's role is basically a power of amendment, the power to remove and replace trustees, the power to direct trustees, and you can add more substantial trust protector powers like mediating disputes, the power to compel an accounting. One of the powers I don't have on here is the power to modify distribution rights. There are many, many things that can be added, but the basic powers are what you see here. Now, as we start to wrap up toward the end of the presentation, I thank you for your patience and your interest today. Let's talk about the different roles of a trustee. And one of the roles is a trustee of a trust under a will. So this could be the trustee of a bypass or family trust that many of you are familiar with in your wills. Or it could be a marital trust between spouses. Who is going to be the trustee of that marital trust, for example? Will it be the surviving spouse? Will it be the surviving spouse and someone else like children, or an independent trustee? Trustees for trust for young beneficiaries. These are children or grandchildren or nieces or nephews, typically under age 30. Trustee of their own trust. This is a person who receives a trust at death from someone else, or even a gifting trust during life. We just talked about the pros and cons of this person being their own trustee in Maryland. If we could avoid that, that would be good, but many parents or grandparents want the beneficiary to be the trustee of their own trust, but many times it's not advisable. And of course, the trustee of a testamentary irrevocable trust of another person. So let's say that it's not for the beneficiary, but the trustee is actually the trustee of another person's trust that was established at death under a will. So wills establish trusts at the time of a person's death if that will is drafted as such. Now, as we continue to think about the role of a trustee, here we have a different situation. Instead of a will, we have a substitute for a will, which is the revocable trust. So the trustee of a living trust is usually you, the person who would create the trust, but there are times, either because of incapacity or death, that of course, that there are successor trustees. Very similar to the will, and I want to go back to the first bullet point just one more time. I want to emphasize that there are successor trustees in revocable trust, and these are going to be the trustees after a person becomes incapacitated. So that's a nuance issue to make sure that I'm okay with who I've appointed as my successor trustee in the event of my incapacity, not just at death. Now, at death, we have the same situation as we have with wills. There could be a bypass or marital trust, meaning some people call the bypass trust a family trust in the old days. This is a spousal trust. Same situation with trust for young beneficiaries. Same situation with spendthrift trust being created for a person that's their own trustee under Maryland law. We talked about the pros and cons of that. And then same situation where a person can be a trustee of a spendthrift trust created for another person, but that trust is created under a revocable trust instead of a will. Now, just circling back to the corporate trustee again, we won't spend a whole lot of time on this, but the experience of a corporate trustee might be desirable. We have many clients who don't want to burden their children or others by being the trustee of a trust. It is a lot of responsibility. So many times these clients will name a corporate trustee or an individual that's independent. But back to the corporate trustee, asset management. Remember, the corporate trustee is not only going to be acting as the fiduciary, but they're actually going to be managing the assets. You have to look carefully at that. They are regulated by state and federal government. They are deemed to be reliable. That's a subjective thing, depending on who you are. They are deemed to have objectivity, versus a family member being a trustee that has an up close and personal relationship with the beneficiary. Many times they can be an excellent referral hub to help the beneficiary be able to have access to lots of services. Not always true in today's world, but longevity is something that some trust companies have, or corporate trustees. And many people feel that they have peace of mind by choosing a corporate trustee, but this is not the case for everyone. This is for someone who in their particular circumstance sees value in the corporate trustee as the independent trustee. Now, as we begin to wrap up, I like to talk about risk as a successor trustee issue. So, as we think about who our initial trustees are, and I know that's a very tough thing to do, and we think about who the successors are, what are the risk factors that we should be thinking about? Well, obvious ones like age and experience. Well, I have people today naming trustees that are over 65, over 70. Many of us know that people are living a long, long time. In my experience, just because someone is 70 years old does not mean they can't be a successor trustee. But one of the things to remember about trustee selection is that as you're thinking about trustee selection, one of the risks to you, which is not on this list, one of the risks to you is that you will not update your planning. If you just simply come to the conclusion about these are my trustees, these are my successors, these are my trust protectors, and you just kind of set it in place and you leave it, that is a danger. So you're taking a risk there by not updating the planning over time. So updating the planning takes out the risk of this first bullet point of age and experience. So just understand there's a risk, but you can mitigate that risk by updating your planning on a regular basis throughout the rest of your life. And that probably can be said about most of these bullet points, but let's go through them. Health and health deterioration over time. So that could affect your trustee, your successor trustees. That's updating is going to take care of that problem. Trusts do not require bond. Now, I'm not going to focus on this, but 98% of the time, maybe 99% of the time, your trust is not going to require your trustee to post bond. It's just too expensive, and it's deemed to be a waste of money. However, you need to think about this and whether or not it ever could be required that a successor trustee would have to post a bond. That's just an issue for counseling. Other life changes of the trustee: divorce, creditors, bankruptcy, unforeseen things. We all know this is happening in today's world at an accelerated pace. Again, the risk can be mitigated by flexibility in the documents and by systematic updating, for example, with our client care program. Disconnection with the needs of the beneficiary. What if you name successor trustees and they look good today, but down the road they are not really connected with the life and the needs of the beneficiary? Now that's a big risk. That risk can be mitigated again with a trust protector and building a lot of flexibility into the document. One of the risks is demands of the beneficiary. Some of you know people who are more demanding than others. We've seen beneficiaries that are either demanding or overly demanding, or not, maybe sometimes not so much. But a beneficiary that is very demanding can actually drive a trustee to resign. And so we want to, that's a risk, and we all we can do is really mitigate that risk in our selection of trustees, and then in our mitigation of that through trust protectors, flexibility, and revisiting the planning over time to deal with such a situation. And we discussed this earlier, the trustee's willingness to serve, their fortitude, their perseverance. It's not easy being a trustee. It's a risky business being a trustee. And we want to make sure that the trustee is willing and that they have the fortitude, not only those qualifications in that concentric circle slide, but they actually have the fortitude and willingness to persevere. That's not an easy thing to do. So we want to mitigate that with flexibility as well. Trustee compensation. Trustees are usually, in modern day approach, they are compensated by what is called reasonable compensation clauses in documents. What is reasonable will depend on the age and experience of the person and whether they're a professional or not, versus statutory compensation. So it's generally thought in our industry that we should not include statutory compensation as a model in the documents, because that is deemed to be a too little compensation for a trustee to reasonably be willing to serve these days. But there are various trustee compensation models, and that's a counseling issue. So as I predicted, we are ready to wrap up now, and I'm going to turn it back over to Jeff. But what I hope that I've done this morning is at least set the stage in the hour or so that we've spent together. I believe we're right at an hour, and we have plenty of time for questions. I'm hoping you use this as a tool. I hope that I've given you something practical to walk away from to jog your mind or to give you a frame of reference about how to think about trustee selection, which arguably could be one of the most important things in planning. I also want you to know that we at Elville and Associates are big believers in education, but we also want to give you a path forward. So if you're a person who's thinking about implementing a trust, we want to help you through counseling and legal education. For you and your fiduciaries, we believe in family meetings. We believe in providing comprehensive education as the best approach in the collaboration process with your advisors. Or if you don't have advisors, we want to help you get a team of advisors, and we have that ability subject to your discretion. So I want to encourage you that we are here. We do not charge to review documents. We have an initial consultation for estate planning or to review your existing thoughts about your estate planning, and we do not charge for that. We have a process where it's predictable and our educational approach, and it's easy to come in and talk to us. We know it's hard to meet people you've never met. It's a strange world we're living in today, sharing personal information, but we want you to know there's nothing to fear, and we're here to counsel and help you forward, whatever your situation may be. And with that said, I'm going to turn it over to Jeff, and thank you for spending this hour plus hour, 15 minutes or so with us on this wonderful morning. So thank you very, very much. Jeff, I'm turning it over to you.
Well, thanks as always, Steve. Well done. And as you said, just such an important topic that I think there's a lot of questions about, and it's something we get a lot of questions about here at Elville and Associates. I know that you and the attorneys always address very thoroughly in our process here with our clients. So I'm glad that we're able to address this a few times a year in our webinars. So we do have a few questions, and we're going to go ahead and address those.
Very good.
And please, now would be the time to get your questions in if you have them still rolling around in your mind out there. So the first question is, with all the experts that need to be involved in the administration of a trust, how much will that cost? How big does a trust need to be to support those expenses? Put another way, how much money should be in a trust?
Thank you for that question. I think that's a very broad question that I won't be able to answer all of it in this time we have, but I'll just give you my thoughts on that. So every trust corpus, meaning the amount of money that the trust has, is going to be one of the considerations. So thank you for bringing this up. I probably should use this as one of my bullet points, that trustee selection is going to also depend on the size of the trust corpus. There are trustees that are willing to serve as long as the corpus is X amount of dollars. There are trustees that won't serve if it's under that threshold, and that's the world we're living in today of increasing wealth and increasing minimums of corporate trustees and individuals and so forth. So I think that's going to factor in. So if it's a special needs trust that only has $300,000 in it, then the corporate trustee or independent trustee candidates are very limited as to who would ever serve for that trust. And also the fees that they charge might be too large for a trust like that, and it wouldn't be practical. So some of this is down to practicality. We may have to use a family member. We may have to use an attorney or someone who's willing to use their paralegals and other resources to work at lower rates for lower trusts, lower asset trusts. On the other hand, the larger asset trusts will not have any issue at all with trustee selection. It's just going to be a matter of preferences and services and the particular needs of the person or the trust. So I do agree with you that that is a big factor. Now, with regard to the other players that are involved, A trust protector can be appointed on a passive basis. And what I mean by that is a trust protector provision can be included that says if a trust protector is needed, then the trust protector can be appointed. And the cost of a trust protector, it depends on what the role is and where we are in the country. But generally speaking, a trust protector would receive reasonable compensation, and their involvement would typically be limited. Sometimes in special needs planning or other planning, the trust protector is more involved than in other types of planning. But generally speaking, the trust protector could play a passive role. Now, there's pros and cons of that. So we have trustees, trust protectors, and in some jurisdictions, we have investment advisors and other fiduciary roles, for example, in Delaware planning. And those individuals are also probably compensated in reasonable compensation fashion. So to answer your question, some of the concerns about costs, which are very important, can be mitigated by how those roles are drafted into the planning and whether they're active roles or passive roles. But otherwise, I agree with you. The corpus size of a trust is going to dictate part of the trustee consideration process, and it's also going to be very important to not deplete the trust with excessive trustee or fiduciary role fees, and that's a situation by situation case. So thank you for asking that question, and I agree with you. That's something that has to be considered.
Yes, thank you for that question. And you mentioned estate and trust administration. We are going to be holding an estate and trust administration webinar this Friday. So if you have anybody else out there and yourself have further questions about understanding the nuances and everything that goes into estate and trust administration, that may be something that would be of interest to you. And I'll share a little bit more about that as we wrap up here. So thank you for the question. Next question is a trust ombudsman the same as a trust protector?
Thank you for that question. I have to admit that I have never heard that before, but from just a general definition of what a trust ombudsman would be, I would say it probably is. Wherever that definition came from, wherever you may have read that, it's probably a similar role as a trust protector, but I have not heard that particular terminology.
Okay. Next question is, can you appoint several successor trustees in case the main successor trustee that is named has passed away, not able or not willing to become the trustee at the time of succession?
Yes, thank you for that question. The answer is yes. We would prefer to see you list several successor trustees. I would say in an ideal world, you would have at least your primary successor, and then you would have two others in a perfect world. But remember that even if you don't have that many, we have a trust protector that can be inserted, and that person can appoint a trustee if needed. And of course, if a trust protector, if we've named candidates as trust protectors and there's no one willing to serve or able to serve as trust protector, there are some backup provisions that can be used to make sure that a trust protector could be appointed. But the answer is yes, please name as many as reasonable in your documents, and we like that.
Okay, next question that we actually answer in our estate planning essentials webinar, and that is, I'm confused about what a pour over will is for a revocable trust. Can you talk a bit about that, Steve?
Sure, I think this is pretty simple to explain. So in revocable trust planning, the trust, if you can see me, the trust is at the forefront. That is the driving force of the plan. Whereas if it was a will-based plan, the will would be the driving force. But in a trust-based plan, with the trust being in the forefront, a will is implemented that stands behind the trust. This is a backup document, and it's a fairly simple document in most cases, and it's called, it's just a vernacular, it's a pour over will. It's just a regular will, but what the will says is that everything that goes through probate goes to the trust. So if you think about that, if there was probate, the assets go through probate. Now, with regard to revocable trust planning, we don't want probate, but what if probate happens? There's an asset that goes through probate. The will dictate that that asset now pours into the trust. So that's why it's called a pour over will, P-O-U-R, but that's just a term of art. It's just a regular will that names the trust. And it's probably not going to ever be needed if the trust funding and alignment of assets are perfectly done, which is our goal, so that probate is minimized.
Okay, thank you. And a comment from our friend Kelly at Maryland Able. Steve, she says, thank you, Steve. This has been a very helpful presentation. I appreciate that Elville has such a strong commitment to educating the community about this important topic and other important planning topics. Well done. So thank you very much, Kelly. And we appreciate you very much. We have a strong relationship with Maryland Able here at Elville and Associates, and actually are welcoming Kelly and Maryland Able back on November 16th to talk about Maryland Able and the Maryland Able account and the benefits it offers our disabled loved ones. So looking forward to that, Kelly. Thank you very much.
Thank you, Kelly. Ditto.
Yeah. And let's see if we have any other questions before we wrap up here. Okay. So going back to the Ombudsman reference, it says, hi, the Ombudsman reference is in the irrevocable special needs trust I have established for my adult disabled son. I will send you a snippet from the document, just FYI, if you would like. So yes, please.
Yes, thank you very much.
If you'd like to send that to Steve, thank you very much. We'd be interested to see that, and Steve may be able to comment further. And it looks like those are all the questions for now. So just a final couple thoughts here. Again, thank you very much for being here. Please consider us a resource if you have any questions, thoughts, planning needs. Again, Steve mentioned document reviews. If you have any estate planning needs that we can help you with now or in the future, please reach out to us. It'd be our pleasure to be a resource to you. And further your education, you'll have your own, pretty much your own webinar, you know, in our conference room, one-on-one with Steve, and it'll be a real good experience for you going forward. So I have some things to send to you in my post-webinar follow-up. I'll be sending the video out for today's presentation. I'll send the slides again. Sounds like we have a couple of people that didn't receive it. They may have signed up a little bit later. And I'll also send out the letter or memorandum of intent that Steve referenced earlier in our presentation. That's going to be a fillable PDF that you can go back to and start it, save it, and then go back and continue filling that out. As it relates to our webinar series, on Friday, like I said, we have Understanding Estate and Trust Administration at 10 o'clock with Steve. On November 3rd, we're going to be going back to a presentation we haven't done in a while, Guardianship and the Alternatives, What Parents and Family Members Need to Know. That's on November 3rd at 10 o'clock. And Wednesday the 10th, we have our advisors forum that we offer every 2 months to our financial advisor community. So we're looking forward to that. And on Friday the 12th, Estate Planning and Elder Law Essentials, which we always try to offer once a month, and looking forward to that as well. So unless there are any final questions, I think we'll call this one a wrap, everybody. So thank you for being here. Thank you for your support of Elville and Associates webinar series and for your interest in Elville and Associates. And we look forward to seeing you again soon. Have a great day, everybody.
Thank you, everyone.